So the Supreme Court has decided to lift the restriction it had imposed on YouTuber and podcaster Ranveer Allahbadia on his show, The Ranveer Show, which means he is now going to be able to resume uploading his episodes onto YouTube, but with conditions. So the Supreme Court has insisted that he furnish an undertaking. So he basically give a promise to the Supreme Court that his shows will, and I'm quoting, maintain standards of decency and morality so that viewers of any age group can watch. Now, the condition not to upload any shows, to quickly remind you, was imposed by the Supreme Court as a condition of interim protection that the court had given him, protecting him from arrest in Maharashtra, Rajasthan and Assam, where cases had been filed against him over comments that he had made in that show, India's Got Latent. Now, it was not just him. The court had also, mentioned 3-4 other people in that case, and I'll come to that in a minute. But I want to tell you what happened in court today. Justices Surya Kant and Koteswar Singh were the two judges on the bench, and they ordered that Ranveer Allahbadia's shows should not comment on any of the proceedings in the court, which are sub judice before the court. And Justice Kant actually took an exception to one of the other accused making comments about the case overseas. Now, this is what the judge has said, and I'm quoting, "One of them went to Canada and spoke about all this. These young, oversmart ones think that they know more than this. We know how to handle," end quote. Justice Kant. I'm reading out of the Live Law website that has this whole case listed out. Now, I think he's referring to the fact that one of the comedians involved actually mentioned this in one of his shows overseas. Now, Allahbadia's counsel, who I'll remind you is Dr. Abhinav Chandrachud, D.Y. Chandrachud's son, he claimed that Allahbadia has no connection with the person who made these comments. Now, in the onset of the hearing, Ranveer Allahbadia's lawyer, Dr. Chandrachud, told the bench that the application has been filed to modify that interim protection and allow for shows to be uploaded. Now, he said that Allahbadia would not utter any word or profanity at all in his shows, and he requested that he be allowed to air shows hosting only spiritual leaders and professionals. The lawyers also said that Allahbadia employs 280 people in his team, and he is solely dependent on YouTube videos and podcasts for his livelihood, effectively sort of arguing that this is the right to livelihood for him and for his entire team of 250 people. Now, the person on the other side was Solicitor General of India, Tushar Mehta, who is the senior most lawyer for the government in the country. He is arguing the case, that shows how important this case is from the point of view of the government, that the Solicitor General of India is arguing it against the plaintiff, against a YouTube podcaster. Now, Mr. Tushar Mehta submitted that he has, and I'm quoting here, watched multiple episodes of India's Got Latent out of curiosity and found, and I'm quoting, the perversity of the program to be of another level. He is actually, and this is Tushar Mehta volunteering, that forget a man and woman, a man and man cannot sit together and watch the show. I'm not really sure what he means. If a man and woman cannot sit together, a man and man cannot sit together. Mr. Mehta's ideas sometimes leave us all confused. He says, and I'm quoting, "Myself and the learned AG cannot sit together when watching these shows. Your lordships will not be able to sit together when watching the shows." The fact that he, Ranveer Allahbadia in this case, chose to participate in such a show, let him remain quiet for some time. So the SG here, the Solicitor General, is actually arguing that an individual be censored, prevented from working, prevented from speaking as some sort of punishment. It would be helpful if the Solicitor General also pointed out what part of our law or our constitution recommends this sort of like timeout silencing for a individual, for a citizen of the country, because you found the content to be offensive. And I don't know what law he's referring to. The SG also added that Allahbadia had not complied with the condition that he should cooperate with police investigations in Assam, to which Chandrachud then pointed out that he responded to the Guwahati police, but the Guwahati police has not given them a date for the summons yet. Now, this is surface level drama. let me take you one step further to why the Solicitor General is here arguing this case against a YouTube podcaster who made a joke on a late night YouTube show. Now we'll get to the actual crux of the matter. During the hearing, the Supreme Court has insisted that the government of India needs to regulate content on online media. And I'm going to quote now what the judge said. The judge said, "We don't want any regulatory regime which leads to censorship, but it can't be a free-for-all. See the quality of humor he has. Humor is something the entire family can enjoy and nobody feels embarrassed. Using filthy language is not talent." End quote. To which the Solicitor General agreed, saying, if you have to use vulgarity to make me laugh, you are not a good comedian. So now the conversation is about what makes a good comedian and what makes a good joke. To which Justice Kant went on to say, think what can be limited, what can be a very limited regulatory measure which must not lead to censorship, which must have some element of control, and something needs to be done. If someone wants to watch something, what do we propose to do? Try to impress upon the union, which is the government, what can be done. Have a healthy debate on it with all stakeholders, end quote. Now, to which at the end, normally these are verbal observations, right? The court and the lawyers speak to each other and then the actual order comes. So, the order basically says that with regard to telecast and airing of programs which are not acceptable in terms of moral standards of our society, some regulatory measures may be required. We've requested the Solicitor General to suggest some measures which are effective to ensure parameters of fundamental rights in Article 19, which is the right to speech, and draft regulatory measures in this regard that can be put in the public domain with suggestions from stakeholders. We are inclined to expand the scope of this proceeding. So, effectively now this case has gone past the India's Got Latent incident, Ranveer Allahbadia's particular show, or what he said or what he may not have said. Now it is about all digital content. We are inclined to expand the scope of this proceeding. So it is now a larger matter that they are looking at, and of course there are previous stories which you can go and look at to find out what this case was about, but really I think everybody already knows what this case is about. Now, far be it from for me to question the Supreme Court and the wisdom of the court and what the court chooses to do. So I want to leave a couple of questions then for the audience, and I want you to tell me what you think. Now, let's take the idea of when we watch something, the whole family should be able to watch it together, and only then it is good comedy or it is good content. So in that matter, I want to place before you a couple of very popular examples. Only in Hindi these examples are, and if we were to expand the scope of this conversation, I'm sure we'll find other examples in any number of Indian languages as well. Take for example the film Masti, Grand Masti, Kya Cool Hai Hum, Kya Super Cool Hai Hum, Masti Zade, Great Grand Masti, No Entry, Houseful, De Danadan, and apparently there was another one. Houseful series actually was released 2010, 2012, 2016, 2019. And these films are quote unquote family entertainers filled with, sexual innuendo and double entrades, basically erotic humor, lots of double meaning dialogue, lots of suggestive humor, lots of innuendo. I'm sure you must have read about them, seen them. These were all released publicly and they made a lot of money in India. Were they good comedy, bad comedy? Should they not have been released? Should they have been released? According to the Solicitor General of India, should everybody be put in time out and told to remain silent for some time without the ability to actually release any more content? I'm very curious to know, and specifically given the fact that the court has asked the Solicitor General to suggest possible regulations for YouTube and digital content, and the Solicitor General seems to think that when you say something that he is not comfortable watching with either a man or a woman, that you should be put in time out and you should not be allowed to speak. So very interesting route that is being taken here, but it seems to me that, like we said last time, the route is actually headed towards regulation of online media. This would mean podcast hosts, this would mean YouTubers, independent journalists will come under scrutiny for the work that they are doing. Now, this scrutiny will give the government oversight over all of the content you currently watch on OTT, on YouTube, on what you listen to on like audio podcasts like Spotify, for example, what you read on your social media sites, what you share on your social media sites, all of this the government will have oversight over, because the Supreme Court has now repeatedly insisted that the government now bring about some sort of regulation in order to preserve morality and the idea of what is good jokes and bad jokes, and what jokes are not funny according to the Supreme Court apparently should not be made, and there should be regulations on what is funny and unfunny at this point. And creators will have to adjust their editorial practices. Now, at this point, I want to quickly remind you that if you were by accident, I don't accuse anyone of doing this on purpose, but if you were by accident to view any television news these days, you will realize that there is hardly any credibility or integrity left on television news, because it was all systematically dismantled over the course of several years. Now, the people who were doing that news have now moved to independent sources. They're using actually YouTube, or they're using Instagram, or they're using social media to communicate the news. All of these people will now come under a list of oversight or of regulation. On one hand, if it is a structure of self-regulation which is already available and which is reasonable, which applies, for example, to newspapers and to television, where you form an association and you self-regulate, that is the way it should be done. That is something that should be welcome. But if it reaches a point where the government gives itself the ability to shut down channels, to take down content that it disagrees with, then basically another route of independent content creation will come under a shroud. Now, apart from that little sliver, there is also the larger pie. People who do podcasts, people who do interviews, people who generally do comedy content, young kids who are creating sort of funny content, satire about their families, about their schools, about their colleges, and putting it out. All of that will come under a certain oversight of, is this bad for the Indian traditional outlook family? Should they be doing this? Should they be allowed? Should they not be allowed? And so there's an entire root of that economics which allows people to put out content and to earn from that content that will all be questioned again. Now, the reason why, again, I want to remind you this is a larger question that you need to answer, is because arguing in a democracy where after the age of 18 you are considered fit, fit to choose your own government. You can vote, you can drive, you can marry, you're able to make your own choices, which means that you should also be allowed to watch your own content, provided there is an age restriction on it. So, and whether you decide to watch it sitting next to a man or watch it sitting next to a woman, and something makes you uncomfortable and something doesn't make you uncomfortable, those are your choices. They are not reason enough, as per our constitution, to censor somebody's voice. That is the thing that we need to examine very carefully as citizens and think about it and have an opinion in our heads as to what we feel about it. Because if the process is followed and there are regulations that are drawn up, they will hopefully be opened up to public debate. So which means that you and me as citizens will be able to write our response and say this is what we think about it. So I would encourage you right now to think about it and to keep a response sort of formulated, maybe do some more reading, figure out how this works in other countries, and build an opinion so that you can be ready to guard your rights when that moment comes. But for now, leave me a comment in the comment section. Let me know what you think, because there are two ways to look at this. There has to be some oversight. This sort of content cannot continue. Government should be allowed to come in and actually tell you what goes and what doesn't go. Or on the other hand, as long as you are above 18 and this content is available to those who are above 18, you're old enough to decide what's good for you and for bad for you. So you decide, and if you don't like it, don't watch it. These are the two options available to you. What would you prefer to do?